Hello all, and thank you very much for joining us on today's webinar. This is part of the Comply Summit Series put on by Performline. And today we are happy and privileged to do this in partnership with Venable LLP, a law firm out of Washington, D.C. Please note that Performline also hosts our Comply, RegTech, and Compliance Conference this coming May 16th and 17th in New York City. Comply2018.com is where you can find information there, and Venables is a great sponsor of ours there. Venables is also presenting on January 11th a Consumer Financial Services Outlook for 2018 webinar, where more information can be found on venable.com. But without further ado, we will dive into today's content. Joining us today are Jonathan Pompan from Venable and Leandra Magaris. I'm David Morgan, the Chief Revenue Officer here at Performline, and the focus of today's webinar is to look at what we can expect from the CFPB now that it is under new management. We know that there may be a lot of questions around these areas, so if you have questions, please submit them through the chat function. It's going to be a pretty packed webinar. If we have a chance to answer questions at the end, we will. If not, we'll be sure to follow up with the person answering the question via email. But without further ado, I'm happy to introduce Jonathan and Leandra. So Jonathan, why don't you give a quick introduction for yourself and your area of focus and expertise.
Thanks, David, and good afternoon, everyone. David, as you mentioned, Venable is a national law firm with offices in Washington, New York, San Francisco, Los Angeles, and other locations, and I'm the co-chair of the Consumer Financial Services practice here at Venable, and we look forward to talking about the CFPB under new management.
And good afternoon, everyone.
Great.
This is Alexandra. I'll just go ahead. Yeah, this is Leandra Magaris,
sure.
counsel in Venable's New York office, where my practice straddles our consumer finance group and our advertising law group, and I work with a variety of companies, banks, non-banks, in Consumer Financial Protection Bureau investigations, Federal Trade Commission investigations, and state AG inquiries as well.
Great. Well, you know, those are the great areas of practice and a lot of the same areas that companies have concerns with when they engage with what we do at our company, Performline. But there's a lot that's coming out of Washington, D.C. lately, and you know, not all of it is super straightforward and clear. And some of that is directly related to the CFPB. So the recent big news out of the CFPB is the change in leadership. And while the change in leadership wasn't wholly unexpected, it did send shockwaves that are probably going to be felt for quite a while. So Alex, let me ask you this. When it comes down to this, this is maybe a real basic question. Who's in charge at the CFPB?
Sure. So just to kind of recap the sequence of events that brought us to today, after a lot of speculation and rumors in D.C. for the last 12 months, on November 24th, Richard Cordray stepped down as the director of the CFPB after 6-year tenure, last 4.5 of which as the director. Right before stepping down, he made a somewhat unexpected move by appointing his chief of staff, Leandra English, as the deputy director, a position that until that time had only been filled on an acting basis. And shortly after her appointment, President Trump appointed Mick Mulvaney, who leads the Office of Management and Budget, to serve as the acting director. So as I'm sure all of you saw in the media coverage of this, what resulted was we had two dueling acting directors that quickly brought this matchup to court. Mulvaney, since being appointed by the president, has been very affirmative in issuing directives, meeting with staff, instructing CFPB staff that he, in fact, is the legitimate director and not to take directions from Miss English as director. And as a result, there's been, of course, a lot of scrutiny and attention on this showdown, but it's also resulted in a lot of confusion and stasis at the Bureau. And that's, something that Jonathan and I have experienced in these last few weeks in terms of interacting with both staff there and helping clients navigate the current situation.
Yeah, and I know that we see that too in our business. Folks are really very much trying to figure out if there's open items that they have pending, kind of what's their path forward. But even with all of that activity, and even with the CFPB's own counsel seeming to side with the appointment of Mulvaney, there's still a challenge here, right? There's some oral arguments coming up on Friday in court. So how much more litigation, if you were to venture a guess, you think is still out there on this matter?
Yeah, that's right. I mean, so we are less than a month after this appointment, and then, the immediate filing of a lawsuit by Leandra English with the district court in D.C. That court had the immediate issue to decide, which was whether or not it should grant an emergency temporary restraining order. It denied that request by Miss English, but it still has to consider the underlying issue on its merits. Again, just getting a TRO is a pretty high standard. That's what was decided several weeks ago. The actual court merits still need to be decided on this coming Friday, the 22nd. Oral arguments are scheduled with Judge Timothy Kelly, who is a Trump appointee, so recently appointed judge to the bench, and then a ruling on the merits could come down any time after that.
Got it. So there's definitely it doesn't seem like there's very clear path ahead, even though there are some what gamblers might say, some tell signs there in terms of things that might happen. Jonathan, what do you make of all of this?
Well, without getting too deep into the weeds on the legal arguments that are now being litigated, we know that both sides, that is the Cordray camp, who appointed English, and the administration, which appointed Mick Mulvaney, had plans for what is happening and what is happening in light of the language in the Dodd-Frank Act and what's called the Federal Vacancies Reform Act. That is to say that Mulvaney's appointment was not random. English, named to the role by departing Richard Cordray, who resigned on November 24th, was also intentional. She continues to assert to this day that the deputy director, quote, shall serve as the acting director in the absence or unavailability of the director under the Dodd-Frank statute that created the CFPB. But under the Federal Vacancies Reform Act, the president gets to appoint vacancies of agencies with some slight exceptions. So that this is part of a concerted effort before Cordray's departure to secure his legacy and the influence over the future of the agency. But conversely, this is also an attempt by Mulvaney to say, as he has, to refocus the agency. And
I know that the head of the CFPB does not serve at the pleasure of the president, correct? So is this a power struggle over the CFPB as a whole?
Absolutely. History and recent history is rich with examples of government agencies being refocused when there's a change in leadership, and certainly when there's a change in the administration. In any event, there's a lot of legal drama going on, but that's not the entire story. There's also the media play, too. So, Mick Mulvaney brought donuts on his first day to control the media message for at least 6 hours, where he courted the senior staff, and the Twitter and other reports coming out of the meeting was that he brought donuts to make peace. But at issue is the CFPB's autonomy, and specifically the power of its director. Directors can only be fired by the president for cause, that is inefficiency, neglect of duty, or malfeasance in office. Otherwise, they serve 5-year terms regardless of presidential transitions. Now, that may change when the PHH appeal is decided. That's another case that's been brewing for years now.
Yeah.
But it may not. And, the CFPB's director is the only appointment that the president or a president gets to make at the CFPB. Everyone else at the now 1,500 to 1,600 agency in terms of full-time employees is hired help carrying out the agenda set out by the director, or at least in the case of the current staff hired by Cordray to carry out his view of what the CFPB is. So, it's largely insulated from politics, except that, with the one exception, they all serve a single director, and that's the power struggle that's taking place. And so, without question, the current staff, with maybe some, slight exception, was hired and supports the mission of CFPB 1.0, the Cordray era, as opposed to 2.0. So that's going to play out as well.
Yeah, and so it's pretty significant, in terms of the impact that this singular role can have on actually the outcome of or future outcomes for the entire agency. So, by all accounts, Mulvaney is doing things pretty differently. He's instituted a hiring freeze. He's put a 30-day moratorium on regulations, and he's reviewing the activities of the Enforcement Office, as reported by the Washington Times. So, from that perspective, that's a pretty significant change, and sounds like a pretty deep dive into what's going on there. Do you think there are? I guess the question is, there's a lot of stuff that's already in progress. We're in the middle of a process at the CFPB with actions and activities around specific companies. How does this impact that, Jonathan?
Yeah, it's a very good question, and it's a question that at least 90 companies or subjects of investigations, probably more, are asking. And while for starters, it means that staff enforcement attorneys are awaiting instructions from their superiors. That's both anecdotal as well as just pretty typical in the case of a transition like this. It's not surprising because there's differences of political and certainly legal views and interpretations. So here, like in other situations where there's an agency transition, there's a review period, and that's going to at least take 30 days, may take longer. According to press reports, Mulvaney himself is reviewing binders and probably reams of paper that have been submitted by staff and perhaps by subjects of investigations. And, with CFPB enforcement, historically it's been used as a substitute for rulemaking, the regulation through enforcement mantra that so many have heard and experienced. And so the types of issues that are likely under review span from systemic policy on particular types of products and services to basics like whether there's enough evidence to merit granting sue or settle authority for those matters that hadn't yet reached that stage. And so that review could take longer, it may not, but at some point we expect that Mulvaney and then appointees for Mulvaney will move to put their own stamp on enforcement priorities and conduct.
And Alex, I mean, a lot of what we've seen in my tenure here at PerformLine, and obviously in the practice that you all participate in there at Venable, is impacted a lot by this regulation by enforcement mantra and actual process from the CFPB. And as you look at Mulvaney's thought process here, like how much do you think that may or may not play into what he's doing?
I mean, so yes. Look, 2 weeks ago, if you had asked me this question, I would have said 100%. There will be, an overall less aggressive use of the CFPB's UDAP authority, and wholesale rewriting of expectations for conduct the enforcement actions under this new management, under the Cordray administration of the CFPB, we certainly saw what has been probably the biggest criticism against the CFPB in spaces like lead generation, debt collection and debt buying, credit card add-on products, how to understand RESPA, which is a statute that had been on the books before, of course, the CFPB came online, auto finance, and other areas. And certainly, that those allegations and criticisms of CFPB overreach very much were echoed by Republicans and the president himself, so ostensibly his appointee, Mulvaney. And I'm still in that camp, but recently both Mulvaney and the president have issued comments about certain prior CFPB actions that and kind of commenting as a fines there were not even enough, right? So there is still a political, PR, populist, strain that could result in even this, new CFPB using enforcement in ways that I think a lot of folks in the business community may not expect.
Yeah,
and that's David.
Go ahead, Jonathan. I was going to add a comment, but I'd love to hear your input.
Yeah, that's fundamentally a really important point. I mean, while there's some uncertainty around just how much the CFPB may shrink and pull back from controversial positions taken during the Cordray era, whether through enforcement exams or even the bulletins that were issued, and I think they will. There's tremendous opportunity, both on the part of the new CFPB leadership as well as also industry and the different sectors and, in fact, individual companies that are in this mix to be part of that conversation. We know from experience with FTC issues, particularly during Republican administrations and states attorneys general, that on some level consumer protection matters are not necessarily always partisan. I mean, certainly hardcore fraud continues to be prosecuted in all administrations, but it can make it more difficult for the agency to move forward on the controversial stuff. So it's important to realize that in the Cordray era, the CIDs were flying, and there were threats of enforcement actions once the investigations were complete. There was very little discretion, both anecdotally as well as also in our own experiences, exercised in trying to reach some sort of middle ground, particularly where there was a stretch in legal interpretation. So it's hard to envision a refocused CFPB being as aggressive or maybe from our perspective, sloppy in terms of sticking to the law. But to Alex's point, there's still plenty of opportunity for the Bureau to both assert its influence and then conversely for industry to also assert its influence. So if it acts like the FTC has operated over the years, there are still going to be areas where staff thinks there's an impact to be made. They just may be different areas.
Yeah, and I think that dovetails well to my next thought and the comment that popped into my mind after Alex's answer there, which is, a lot of the activities here that the CFPB pursues and has more purview over are enforcement activities that had traditionally been under the purview of states attorneys general, the FTC, Departments of Banking, the OCC, Department of Justice, et cetera, et cetera. So even if the CFPB were to get stripped of any intent to continue on the path it was on under Cordray, I think, companies ask us all the time, like, is this a point where I can breathe a sigh of relief? Does this mean that those things that I felt tied down to or shackled by are no longer applicable? And we advise companies very clearly that the CFPB was covering a lot of ground that other agencies have purview and cover also. So I don't think from that perspective it necessarily means that now that Mulvaney's in there and assuming he can overcome any legal challenges, that concerns or issues raised by the CFPB necessarily go away. But companies have been investing a lot of money around compliance management. CFPB definitely changed the way in which companies thought about compliance monitoring and management when it came online, and big impacts definitely for non-banks. The banking community, a lot of this was further enforcement and regulatory activity around things they had been paying attention to, but for the non-banks, a lot of this could have even been termed as net new for them, even though they were in regulated industries. From your perspective, like how long is there a window here where folks say, you know what, everything we're working on, we can throw that out the window, or would you still advise folks to carry on the path that they've been working on under previous CFPB guidance?
Yeah, I'll take that one. I mean, look, obviously, I think it would be very short-sighted to just kind of look at, these current events, snapshot in time today, and make decisions about, investments that are already in place or have been committed to on compliance. I mean, first and foremost, having these investments, a strong compliance program, allows you to defend actions that come from a variety of sources. The CFPB being only one, and being kind of the most, out front these last few years. Before the CFPB came online, Jonathan and I had a very healthy practice defending companies before the Federal Trade Commission and state AGs. That's not going to change. And in fact, when you think about both FTC on the federal, state AGs on the state level, they've learned a lot from the CFPB, especially on the compliance systems front. And you're seeing a lot of states, including state licensing bodies, but also the law enforcement bodies, looking at compliance differently as a result of CFPB guidance and the way the CFPB was able to use that as a tool. Importantly, the UDAP provisions of Dodd-Frank, which we just discussed in terms of the CFPB using them to regulate through enforcement. The state attorney, the Dodd-Frank statute, very presciently potentially, includes a provision that allows state attorneys general to enforce the Federal Consumer Financial Protection Act. Without that very specific provision, the state AGs would not be able to enforce federal law, and so that is a powerful tool in their belt. And we know for a fact at least 17 AG offices, recently wrote to the president, imploring the president to not essentially defang the CFPB, but also committing themselves to fill that void. And although states are, inherently more limited than the CFPB, they are getting more sophisticated and used to multi-state investigations, which do allow them to have a national or close to national reach, whereas if they bring these one-off investigations, they're probably more limited to their own boundaries. And so I think even if the Cordray era and even during the Cordray era we saw states partnering with the CFPB, I think we're increasingly going to see them go at it alone and try to enforce these UDAP provisions. And my concern is, of course, having 17 or 50 or, many different states coming up with their own tests and their own standards for UDAP. That can make things exponentially more complicated and difficult to predict and to, develop your compliance processes to accord with with multiple states' versions of UDAP instead of just having a single CFPB voice speaking in terms of those standards. So for those reasons alone, I think these compliance programs should not be neglected.
Yeah, and I think that. Sorry, go ahead, Jonathan, please.
David, a lot can change before all the dust settles too. So Mulvaney could stay on for up to 210 legislative days, just under the way he's been appointed now. That clock stops if the president nominates a permanent director for consideration by the Senate. But perhaps most important, not only is the UDAP authority able to be used by others, and in some respects looks a lot like what the states and the FTC use all the time, as Alex mentioned, but the pendulum swings back and forth. And the Cordray CFPB didn't let their start date get in the way of looking way back in history in terms of finding potential alleged violations of law. While that was controversial, the acts of the past, or in this case perhaps the acts of the present, can catch up to an organization. So the ability to be able to defend on that and to be able to demonstrate legal compliance does not fall by the wayside now. And just to return from a comment from earlier, David, let's just say there's enough to shift to support unwinding de-risking. For many years now we've heard about de-risking, Operation Choke Point type activities and others that were either stimulated by government policy and regulatory agencies or by industries. It's going to still be important for the I's to be dotted and the T's to be crossed now, because if companies unwind de-risking and enter into markets that perhaps, or offer products and services that perhaps they didn't offer before because it was just convenient to say no as opposed to take the risk, the degree of risk, the nuance is going to be extremely important. And that's where good compliance and legal and outside counsel and services and vendors can really work together to dial it in, so that way even though what may have been something that was foreboding in the Cordray era, simply based on a perception of risk, it may not in fact actually be as risky. So compliance is going to be very important there, as well as also industry self-regulation.
Yeah, and then the comment I was going to make is, from personal experience, in a prior life dealing with mortgage licensing regulations by state versus there being a federal standard is not efficient, right? And to your points here, a lot of these consumer protection activities are enforceable at the state level. A lot of states themselves have consumer protection regulations on the books that they can enforce individually too. So I think one of the key takeaways that we see across all the folks we speak to is that just because this one entity may get stripped or tuned down, in no way, shape, or form diminishes the risk of the market. And if anything, in certain states, it may actually amplify the activity at the state level. And when you take the ability to have consolidated focused defense, you have to fragment it to defense of multiple state activities, it can definitely become more problematic, unequivocally become more expensive, and very much more resource intensive. So I couldn't agree more on your points. I guess a last question here. The new management obviously is going to have impact on rulemaking, but do these changes at the top, if Mulvaney drags his feet on the review, does that mean that just by dragging his feet on the review, he could ostensibly pause rulemaking for an undetermined period of time?
I'll take this really quickly. Certainly the moratorium will likely extend beyond 30 days, but I don't expect the entire rulemaking agenda, given how much work has gone into the pending rulemakings, to be completely derailed. I think the outcome, the specifics of the proposed or ultimate rules could be different, but I don't think the overall agenda will be derailed.
Yeah, David, there's just a lot of unfinished business. So different sectors may not have wanted a particular outcome, but in some cases, rulemaking would have been useful simply because the statutes that are being enforced today may be antiquated and out of date. The Fair Debt Collection Practices Act hasn't been touched in in decades, and some level setting and modernization there and other places, could be welcome to industry, but only if done the right way. And so the question is what's next here? But there is unfinished business.
Great. Well, and hopefully unfinished business means that as new developments come, we can do this again and stay a source of information and opinion for folks who can find it of value. So with that, unfortunately, we're out of time today. I hope everyone got a lot out of today's webinar. Please do join Perform Uneventable at Comply 2018 this May 16th and 17th in New York City, where this will be one of many, many topics we'll cover. And also in January, on the 11th, make sure to register for Venable's Consumer Financial Services Outlook for 2018. Thanks very much. This recording of today's webinar will be available on YouTube. So please let us know if there are any follow-up questions that you would love us to respond to. And thanks again, everyone, for tuning in.
Thanks, David. Happy holidays.